Warrensville Heights City School District. Dr. Rock, would you please call the roll?
Mr. Freeman,
Here.
Miss Mitchell,
Here.
Mrs. Moomin,
Here.
Mrs. Gator,
Here.
Mr. Roberts.
Here. Everyone is all present and accounted for. Next item, will we all please stand for the Pledge of Allegiance?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
That brings us to item 1.3, the approval of the agenda. Are there any amendments to the agenda at this time?
Mr. Chair, I'd like to ask that we please make a correction on item 2.1. Legal update, we have it listed as Pebbles and Wagner, and it should be Pebble, PP instead of BB.
All right, thank you. Ms. Mitchell, do we have a second to that motion?
I second the motion.
All right, motion has been properly moved and seconded. Dr. Rock, would you please call the roll?
Mr. Freeman,
Yes.
Miss Mitchell,
Yes.
Mrs. Moomin,
Yes.
Mrs. Gator,
Yes.
Mr. Roberts.
Yes, motion passes motion passes 5-0. The agenda has been updated. Do we have a motion to approve the updated agenda?
Mr. Chair, I move that we approve the updated agenda for May 8th. Not second.
All right, it's been properly moved and seconded. Dr. Rock, would you please call the roll?
Miss Mitchell,
Yes.
Mrs. Moomin,
Yes.
Mr. Freeman,
Yes.
Mrs. Gator,
Yes.
Mr. Roberts.
Yes, motion passes 5-0. The agenda is approved. Next item on the agenda is 2.1, legal update. That will be from Mr. Chris Williams from Pepple and Wagner.
Thank you. I have a handout for the board I'm going to provide to you if I could.
Yes, sir.
Oh, thank you. I'm sorry.
Thank you, sir.
Thank you.
Thank you.
Okay, thank you for your time this evening. I'm here to talk to you about Ohio's Open Meetings Act and compliance with the Ohio Open Meetings Act. The reason, as I understand that we're here, is that it's good to have a refresher on what Ohio requires of public bodies like yours when it comes to having your meetings open to the public, the requirement that you provide notice to the public of the meetings, when you can go to executive session, how you go into executive session, what constitutes a meeting. And so I'm going to spend time going through those items tonight, but I'd like this to be tailored as much as possible for what you have questions about. So as I'm going through this presentation, if anyone has a question they want to ask or seek clarification or something they've been wondering about, please feel free to interrupt me and ask me the question. I think sessions like this work a lot better if I'm answering what you want to know rather than just me talking up here. So with that said, Ohio's Open Meetings Act is Revised Code 121.22. That is the law that requires public bodies such as this Board of Education hold all of your meetings in public session, take all official action in public session, make sure you deliberate, except in certain special exceptions, deliberate on all items in public session, and that you properly provide notice to the public of your meeting so that members of the public know when and where and about what your meeting is going to be. The important thing to remember about this, and this is a question we get frequently from clients, I'll get questions about, do we have to do this a certain way in open session? Do we have to, is there an exception that allows us to get around the Open Meetings Act? And what I always tell people is if there's not a clear-cut answer, remember that a court looking at any question about the Open Meetings Act is going to look at it and say, hey, we want to interpret this in favor of the broadest possible access of the public to see and observe what you do as a public body. So if there's a gray area, in which way is the court going to go on that? They're pretty much always going to go in favor of more openness openness, more exposure, more sunshine to what you do rather than less. And it's sort of a cornerstone of the proper function of government and being accountable to the people that elect you to the positions that you hold. And besides the fact that it's required by the law, I think it's a good idea. I think it provides accountability and has the public help trust what you are doing when they see what you are doing. And that trust in turn helps you do your jobs better as board members. So let's get into some of the definitions that govern the Open Meetings Act. First thing is the definition of a public body, because the public bodies are the entities that are subject to the Open Meetings Act. What is a public body? Well, simply put, it's you, a board of education. There's all of the kinds of public bodies like city commission, township trustees, parks and rec boards, things like that. But for purposes today, I'll be looking at you as a board of education. You're a public body for purposes of the Open Meetings Act. But you're not the only type of public body that you come into interaction with that is subject to the Open Meetings Act. It's not just the board that makes decisions. You also have committees, and those committees will make recommendations to you. And the laws make clear that, in general, any committee that's been established by the board or is a committee that's required by law to exist for the board is a public body and subject to all the same requirements that you're subject to as a public body, which means giving notice of the meetings, keeping minutes, making sure you only go into executive session for proper purposes, et cetera, et cetera. And that's something that sometimes public bodies forget. They'll think, well, it's a small committee meeting. It's not the whole board. There's only 2 board members here, or maybe only 1 board member there. Maybe the Open Meetings Act doesn't apply. The law is clear that if the board establishes a committee, the Public Meetings Act or the Open Meetings Act is going to apply to that committee. The only types of committees, yes.
So when it comes to, but we're strictly talking board committees, accounting and finance, if we did that as a board committee, policy, what would constitute a subcommittee of a board committee? We've never done that. I don't think we would, but.
Sure, and the statute uses subcommittee. I think it really is just another term for committee, because there's some public bodies that might be called a committee, and they might have subcommittees. So for purposes of the board, you have committees. But there will be some committees perhaps are not subject to the Open Meetings Act. If, for example, the superintendent wants a special study into an effective technique for teacher evaluation, he's going to establish a committee for purposes of that, put a couple of principals, a couple of teachers on the committee. He's going to chair it. It's nothing that the board has set up. It's simply something that the superintendent's looking into. That's not subject to the Open Meetings Act because the superintendent has established that committee. But the example you gave, Mrs. Gator, the policy committee, perfect example of would be a committee of the board subject to the Open Meetings Act. One thing the courts have also made clear is that the board can't say, well, we don't want our Buildings and Grounds Committee to be open meetings. Let's delegate the Buildings and Grounds functions to the superintendent, and the superintendent can establish that committee on our behalf. Law says we can't do that kind of workaround. So if it's something that the board wants to set up as a committee, it's a public body subject to the Open Meetings Act. So listen, we talked about what a public body is. Let's talk about what a meeting is, because that's also a legally defined term for purposes of the Open Meetings Act. A meeting, and I'm on page 3 at this point of the outline, top of the page. A meeting is any prearranged discussion of the public business of the public body by a majority of its members. So there's a few phrases in there. We're going to get into what they mean under the law. A prearranged discussion, we'll talk about what that means, of public business by the public body, we've already talked about what the public body is, and a majority of its members. That's when the Open Meetings Act is going to apply. So let's talk about a prearranged discussion, and what does that mean? For purposes of tonight, back when you had your organizational meeting, you set this meeting as a work session that would be happening on May 8th, it would happen at 6:30, and it would happen here. That's a prearranged meeting where the date, the time, and the place are all set ahead of time. But it doesn't have to be just in that fashion. It can be a special meeting notice that's given out to the media. Let's say you learned that next week there's something you need to meet about that wasn't thought about before. You ask Dr. Rock to put together a notice, sent it to the media. That's also going to set forth the date, time, and place. That's a prearranged discussion. But prearranged discussions can also happen when it's an effort to skirt the law. And that's, when the lawyers get involved because someone finds out, they sue the board, and there's a question of whether it's prearranged or not. So for example, if the board decided to get together one evening, have a game of poker, go to someone's house, have a game of poker. Everyone's agreed to meet at Mr. Roberts' house at 7 o'clock in the evening. He'll have wings and refreshments for everyone, and you'll play a game of poker. Well, is it prearranged? Place, date, and time has all been set. That could be considered a prearranged discussion. So then the questions I'm going to turn, is that an unlawful meeting of the board, is based upon how many people show up. Is it a majority of the members? Do you get at least 3 of the 5 board members showing up for that meeting? And are you going to have a discussion regarding public business? If all you talk about is poker and how the Cavs are doing and how far are they going to go in the playoffs and how are things looking for the Browns, and you never get into any of the business of the school district, technically it's not a prearranged discussion of the public business. The problem is when you have dedicated public servants who live, breathe, and sleep how to make this a better school district, it's almost impossible to think you're going to get 5 board members together for any extent of time where they're not going to talk about the public business of the public body. So we certainly advise our clients, if at all possible, don't have functions where it's just the board members getting together at a prearranged date, time, and place. Because if someone starts talking about the public business, you could be converting that non-meeting into a meeting. So prearranged. There are times, it's a small enough community, you could be shopping at the grocery store and you run into another board member in the aisle and you turn and look, well, there's yet a third board member in the aisle. Are you now having a legal board meeting? Well, it wasn't prearranged unless everyone agreed to meet by the produce section in the grocery store. Things like that, the law doesn't contemplate as being unlawful. So even if the members of the public see the 3 of you suddenly in the same aisle at the grocery store, unless you were thinking about meeting there and prearranged it, that's not going to be a public meeting for purposes of the Open Meetings Act. So we talked about prearranged, we talked about discussions. One thing I think is important to talk about as well is what is the public business? Because that's a very wide-ranging definition and basically means anything that touches upon the business of the school district. So if you're talking about who you're going to hire as a teacher, how much you're authorized for collective bargaining negotiations, what are you going to do with that construction project coming up? Whatever the case might be, and it impacts the district, that's the public business. And because there's so much that you do that touch upon the lives of people in this community, that's a pretty broad thing. So in general, if you have a majority of the board members together at a prearranged date, time, and place, likely some of what you're going to talk about might be the public business. But it's not just when you're physically present with each other that the Open Meetings Act can be implicated. There's other times that the courts have looked at that sort of recognize the modern realities of how we communicate that bring other examples of prearranged discussions. One such example is when you email with each other. Now, so let's say Dr. Rock sends an email out to the board members about an item. And then one board member responds to all. Well, I'm in agreement with Dr. Rock sent out. I think we should approve this contract. Another board member says, no, this is crazy. We don't need to approve this contract. We just approved this kind of contract last year, and they didn't even meet their goals. And a third board member chimes in with his or her opinion. Before you know it, you've got multiple board members giving their opinions on this contract. Guess what? You got an illegal meeting going on at that point. And one thing that I encourage districts to do, because I know there will be times when either Mr. Jolly or Dr. Rock will need to communicate with the board about something, I always recommend send it in a way that board members cannot all respond to each other. Because even if you inadvertently start doing that, you could create an illegal meeting. And because those emails, by and large, unless you meet a specific exception, are going to be public record, it's something that somebody could request, take a look at, and file a lawsuit over. I've got a case in the outline that talks about an example where that happened, White versus King. I just want to go over it briefly because I think it's a good example of how unintentionally a public meeting can break out that's illegal under the Open Meetings Act. So in White versus King, this is one of those boards that had that one board member that didn't really get along with the other board members. And the board had decided to do something properly in public session and voted on it, and this one board member disagreed. And that one board member, who's the one of the 4-1 vote, wrote an editorial letter to the editor objecting to what the board had done. Well, this upset the board president, it upset the superintendent, it upset the business managers, so they all start talking back and forth about how they could write a letter in response to that and get that published in the newspaper. And so the superintendent took a cut at it, circulated amongst the other 4 board members. Well, pretty soon, everyone's commenting on how they're going to revise this letter and get it published in the newspaper. Suddenly, this letter gets published. And the one board member who was not part of that group thought, well, how did they put that letter together? How did they all know what it was going to say and get it into the newspaper? So he starts making public records requests and comes to find out that board members are communicating by email about the contents of this letter. And ultimately, the Supreme Court said that was an illegal meeting and sanctioned that board for having conducted an illegal meeting by email. Yes, Ms.
I have a question. We used to have a problem, but we stopped because we make it very clear via text or by email, this is not to be responded, respond back to the sender individually. So my question is, if we respond back to the sender individually, at that point, it is not a meeting because we're going back directly to either Mr. Jolly or Dr. Rock or the board chair with the response.
Generally speaking, Ms. Mitchell, that's correct. There'll be an exception I'll get into in a minute, but generally speaking, yes. If Dr. Rock sends out something and you read it and say, we need to amend the agenda because the law firm's name's incorrect, for example, and provide that as an example back, that's not going to create an illegal meeting. But I'll get into an example in a little bit that could present a problem in that kind of scenario. So we talked about email. And in fact, the next case in the outline even talks about the situation you raised, Ms. Mitchell, where one email sent by a board member to two other board members with no responses or counter responses doesn't constitute an illegal meeting. Similarly, if a superintendent or treasurer sends something out with one response, that's not going to constitute an illegal meeting. Because the mere passive receipt of email doesn't create an open meetings issue. That's just communication, and that's something your superintendent treasurer should do and do with you. Another example, and this sort of existed prior to email, we hear all the time, would be the calls, the series of calls that can happen where a superintendent or someone decides to start calling all the different board members and getting input from all board members and responding to the board members. Here's what all the other people had to say, and sort of acts as a conduit through which all the opinions are filtered. In that scenario, that can potentially be an issue if you have one person serving as a hub almost, as everyone's going back and forth to one person, that person's dispersing the information to everyone. And the goal being, well, we're not all together at the same time, but the reality is you're still exchanging the information amongst everyone in that way. That could be considered an unlawful meeting if that happens. Again, I think that's been talked about by a lot of cases, whether it's by phone or by email, and people avoid doing that anymore. But I do know some districts that still sometimes do that, and that can be a concern if they do that. Another example, and this happened with Cincinnati. This was the city of Cincinnati. They were looking to build a new football stadium. They were talking about, with the architect and the contractor, what the stadium is going to have, and there were some concerns about it. They don't want to go to the public with it yet, and so they decided to have a bunch of different mini meetings where two council members out of the 7-person council would meet at a time with the architect and the contractor, and they'd have 2 people come in and leave, and those people come in and leave, and other 2 people come in and leave, and they thought, oh, we're being clever. We're never going to have a quorum, therefore it's not an illegal meeting, except the Supreme Court found that that was an illegal meeting because these back-to-back meetings where everyone's getting the same information, can ask questions, can constitute an illegal meeting. That's what the Supreme Court determined in that case. Other types of communication, Ms. Mitchell, you raised texting a moment ago. That's sort of the latest thing we see with this texting or instant messaging that can occur. And again, the format of the messaging doesn't matter if it's still accomplishing the same thing, allowing board members to interact with each other, whether it's in person, over the telephone, electronically, through Skype, Zoom, text, email, whatever Slack, whatever the medium might be, if it allows that interaction between a majority of the members of the board about the public business, that could constitute an illegal meeting under the Open Meetings Act. Yes.
So we will sometimes all go to city council meetings. Sometimes the mayor will say, hey, would you give us an update? So if somebody stands up and gives an update and the rest of us are there, but we're not conversing about it, that's not an issue, right?
Correct, because that's not a discussion of the public business. Someone's providing an update, a one-way communication to the mayor. Now, if suddenly board members start going back and forth and talking about, well, I know we talked about we do this whatever, have a function in the park, and I don't think we should have the function in the park, and then someone else chimes in, and then all of a sudden there's a conversation, that could be an issue. But if it's simply a board member providing an update to city council, that's not a public meeting. And I've known, and maybe I think you've probably done this as well as a board, there's been times where there's a concern that there will need to be interactions between board members and city council members. And I've seen there be joint public meetings that occur where both entities provide notice of the same date, time, and place to make sure they can have those kind of joint discussions.
I have another question. So you guys Google Docs on here. When we did our presentation at OSBA for Capital Conference, there were 3 school board members along with Mr. Jolly and Dr. Rock that was part of the deck. It was pushed out for review, and there were 2 of us that worked on building the deck. Does that constitute, because I see you've got Google Docs on here for collaborative document creation. Does that constitute an open meeting, even though it was 2 people working on that deck?
So the concern with that, and without knowing more about the specifics, and we can, if we need to, we can talk about it later.
About board governance.
Yeah, if it's, and by the specifics, I mean, a lot of these electronic Google form documents will have the ability to put comments on the side. And so someone might add a paragraph and then provide an explanation as to why they've added that paragraph. And then someone makes revisions and then provides their explanation as to why they've made the revisions. And then suddenly people are going back and forth about that. It's possible that kind of thing could constitute a violation of the Open Meetings Act, because it may simulate as if the 2 or 3 of you were sitting in a room together talking about what the policy should say and rewriting the policy. So it really depends upon that level of detail. If it's simply
2 board members can be in a conversation together.
Yes, 2 board members, provided that they're not on the same committees. Let's say this was the policy committee and there's the 2 members of the policy committee, then you still have an Open Meetings Act issue there. But if it's simply 2 board members out of the 5, then you don't have a majority, then that's not an issue.
Thank you.
You're welcome. So there have been times, and I don't mean to pick on my good friends from OFCC who are here this evening, but I know a lot of times they have asked for this of public bodies, where they'll want to present information about a construction project, or maybe there's design plans, things of that nature. It's not something ready to be rolled out to the public yet because you're still figuring out what to do, and they want to be able to get the information to the board, but they don't want to have it at a public meeting yet. Sometimes they'll say, hey, we'll have an informational session where you can come as board members, and the architect or the contractor will present something to you, and you can receive that information. And that's not a public meeting, so you don't have to worry about it. That is technically true. If you can all sit there like potted plants, not say a word, and just passively receive information that's being provided to you, and then you get up and you walk out of the room, you don't talk about it, you don't ask any questions, you don't interact with each other about it, yeah, that's not a public meeting. It makes me nervous when that, you might have the board member who can't resist, they can't help themselves but to start asking questions and probing, and before you know, another board member starts interacting as well, and now the 2 of them are discussing it, and something which was simply intended to be an informational session where you're only receiving information, you're not actually going to be deliberating, discussing it, transforms itself into an illegal meeting. And there's been a number of cases, I cite a bunch of them in the outline, that have looked at the situation. Sometimes they find, because of the specific facts, not a violation. And sometimes they find, because of the specific facts, that there was a violation. So in my view, it's better to avoid the situation altogether. But if you're going to take that risk, exercise self-discipline and don't deliberate, don't talk with each other, simply receive the information that's being provided so you can process it and then have those deliberations later on at a public meeting. Work sessions, workshops, work retreats, like today, for example, this work session, still a public meeting. You still noticed it. The public's still able to come and should be coming to these meetings, and just like a regular meeting or a special meeting. One exception the law does specifically provide is for collective bargaining. Your collective bargaining sessions are not public meetings. Even if you have 3 board members on the bargaining team, that's a majority of your board. And certainly negotiations with the union is a public business. But because there's a specific exception for that, you can have 3, 4, 5 board members on the collective bargaining team and not have it be a public meeting that has to be called. Now, there's other reason I don't think it's a good idea to do that from a negotiation standpoint, but from an open meeting standpoint, it's not unlawful to do that. Openness. One of the, as I mentioned during my introduction, one of the bedrock principles of our form of government is that we are open and accountable to the people. And that's one of the primary duties of a public body is openness to the public. And that comes through again and again in any of the court cases you read about the Open Meetings Act. So what does that mean? It means in part that when you have a meeting, you have to have it somewhere where the public can attend. Here, you have it at the municipal center. This is sort of the hub of government for Warrensville, and people know where it's at. Readily accessible. This is a large room. We've accommodated a large number of people. I know there's been times that I've been to your board meetings where you have even more people, and you do them perhaps at the high school, and you can be in the auditorium where even more people can be accommodated. Having a venue that's open like that is important for purposes of openness. One of the things that, I guess a good byproduct, if there are, you want to call it that, of the pandemic was that a lot of public bodies started to embrace putting their meetings online. So you still have an in-person meeting. People can come sit here and watch your meeting. But if they want to, if they're not able to, for whatever reason, they can tune into your YouTube channel or Facebook page or however you broadcast it and get it that way as well. And that's certainly something to be encouraged from an openness standpoint. One of the things that used to be a big issue, it's not as much of an issue anymore, but there was a time when public bodies got real touchy about people bringing in video cameras and videotaping the meetings. Even though it was supposed to be open to the public, they thought that was a concern. And part of the reason it was a problem was because, back in the 70s and 80s, if I wanted to record your meeting, I'm bringing a camera crew in here. They're setting up a tripod, and there's all kinds of cables that are running over. You might be tripping over them, and the camera's blocking people's view. Nowadays, if I want to record your meeting, I just take my phone out, hit record, and very easy to do. It's not obstructive, it's not bothersome, and something the public's allowed to do. And the cases have made very clear that audio and video recording by the public of your meetings is permitted unless they're being disruptive while doing so. Meeting minutes. This is sort of the flip side of it, as well as the requirements of the Open Meetings Act. It's not just you've been open, but there's been an accurate record of what's happened at this meeting so that 2 weeks from now, 2 years from now, 2 decades from now, someone can go and find out what happened at this meeting tonight. The obligation, and a lot of this falls on your treasurer, is to make sure that you've got full and accurate minutes of what's happened in the meeting. Now, it doesn't have to be a verbatim transcript. I've seen some public bodies that have verbatim transcripts. It can be tiresome to read through that, and that's not a requirement of the law. There has to be sufficient information with enough facts and information to permit the public to understand and appreciate the rationale behind a public body's decisions. So certainly having the motion, the second, the vote on it is important. Courts like to see if there was any discussion and a summary of that discussion so that people can understand when they're looking at it at some later point what was talked about and why the decision was made. The minutes only need to reflect the general subject matter. Again, it doesn't have to be so detailed that it looks like a transcript of what happened. One requirement of the law is that the minutes of a regular special meeting shall be promptly prepared, filed, and maintained, and open to public inspection. I know on your website right now you have that kind of information that goes back for a number of years. I know that you've got in your office decades of books of minutes, and that's all what you have to do under Ohio law. Sometimes we get asked the question, we tape record our meetings. Doesn't that mean that's good enough? And my tape recordings let you see everything that happened. So what is Treasury have to put together minutes if there's an actual tape recording or video recording of that meeting? The only caveat with that is think about all the different times you've purchased your favorite album. You got it on vinyl, and then you got it on tape, and then you got it on CD, and then you downloaded an MP3, and they got it from iTunes. And you think of all the different formats that have existed over time. Those formats continue to change. And just because you recorded your meeting in a certain format today doesn't mean that 20 years from now that same format is even going to be accessible. Try finding a CD player or a tape player nowadays. It's almost impossible. And yet you have perhaps meetings on tape that can't be played. Sometimes those tapes degrade. CDs get scratched, and that becomes a meeting that's lost if that's the only way you've preserved what happened at that meeting. So certainly there's nothing wrong with recording your meetings, keeping those recordings and having them available, but I still think it's best practice to create minutes just like they were done 100 years ago. You put them to a minute book, and that minute book is kept in a safe location, and that is the official record of what you've done at your board meeting. Then let's get to the next part, notice of your meetings. It's all well and good to have a meeting that's open to the public and that you have all your deliberations publicly, but if people don't know when and where that meeting is, have received proper notice of it, doesn't do a lot of good. So you have to establish by rule a reasonable method of notifying the public in advance of your meetings. And that's in your board policy right now. You have that rule in your board policy. And that's set for purposes of your regular meetings. At your organizational meeting, the first meeting of the year, you set the date, time, and place of all your regular meetings. And usually, I think you have them regularly every couple of weeks. You have work sessions like tonight. That's all set forth, and that's how you let people know about the regular meeting. What many districts do, and I think you do as well, is you'll publish that as well on your website. And so that people can still check there. If they weren't at your organizational meeting, they still get regular notice of that. In addition, there's also special meetings. Special meetings, we talked about before, those meetings where they weren't originally planned, but you need to have the meeting, and there has to be a way of giving notice of those types of meetings as well. In addition, there's a requirement that with special meetings, not only you have to provide notice to the media of that meeting at least 24 hours in advance, but also have to provide notice to anyone who's asked to receive notice of your regular or special meetings. You can do that through mailing it to them, emailing it to them, providing to them in some way that they can receive actual notice of it. I can tell you that there's a number of boards that I'm on their list, and I'll receive regular emails of their regular and special meetings with the agendas attached because it's something that we need to keep track of. And that's a requirement of the law if you've had someone that asked to receive the notice of your meetings. So I mentioned special meetings are basically any of the kind of meetings you have that's not a regular meeting. Special meeting can be called by the president of the board, the treasurer, or any two board members who want to hold a meeting. So a lot of times it might be Mr. Roberts communicating to Dr. Rock, he can get notice out, and that can happen, but it doesn't have to be Dr. Rock. The law expressly allows for just the board president or any two board members together to call a special meeting of the board. As I mentioned, special meetings do need to provide notice at least 24 hours ahead of time to the media, and that notice must set forth a few things. Again, the date, time, and place of the meeting. You also have to set forth the purpose of the meeting. This is what differs with the regular meeting. With regular meetings, you don't have to set forth what the purpose of that meeting is going to be. Any business of the public body can come before the Board of Education at a regular meeting of the board. Special meetings, on the other hand, all you can discuss at a special meeting is whatever you put in the meeting notice was the purpose of that meeting. So if the purpose of the meeting was to hire a third grade teacher, and that was the only purpose, and then you have the meeting, and during the meeting you start talking about hiring a cafeteria worker, approving a copier contract, things of that nature, guess what? You violated the Open Meetings Act because you've gone beyond what the purpose of that meeting was. The law also requires that when you provide that notice, that someone looking at it must be able to look at the notice and understand what the purpose of the meeting is. So all you have in there is personnel. Probably not going to be specific enough for purposes of a special notice or special meeting notice. It has to be hiring of a teacher or discipline of a custodian, something specific enough so that someone looking at, oh, geez, I'm curious about who they're hiring. I'm going to go to the meeting, or I don't care about discipline. I'm not going to go to that meeting. You're not required to put the person's name in that special meeting notice. It doesn't have to be that specific, but it does have to be specific enough so that someone looking at it can understand what the meeting is about. I've seen some boards do this where they get concerned that something might come up that we want to talk about at that special meeting, but it might not be on the notice. How about we put it on the special meeting notice, for purposes of approving a contract with a textbook vendor and any other business which may come before the board. That catch-all is not a get-out-of-jail-free card when it comes to the Open Meetings Act. It's too vague, doesn't specifically say anything, and it's not going to be sufficient for purposes of getting around the requirement that your special meeting notice must say expressly what you're going to talk about. So we talked about how special meeting notice under the Open Meetings Act requires 24 hours notice to the media. But there's another statute for boards of education specifically, 3313.16, that requires at least 2 days notice to the board members. Now you think, well, that's even longer than the special meeting notice. How is that going to work? What if we only have 24 hours? Well, the law does say you need 2 days notice to board members. It's got to be in writing. But if all board members still show up to the meeting with less than 2 days notice, then the way the law interprets it is that everyone received that notice and they're there. So even though it wasn't 2 days, you still received enough notice you're physically present at the meeting. The issue only comes up, and I've only had one case ever where there was less than 2 days notice and there was a question about whether or not a board member who didn't show up properly received notice at that meeting if it was a legal meeting or not. And in that case, they found it was a legal meeting because the person actually admitted to knowing that the meeting was going to occur. But I think it's a better practice that with your special meetings, if you can, do the 2 days notice, make sure that all board members do have adequate notice on their 13, 16, or ensure that you'll have all 5 board members there so you don't have a concern with that. Now, that provision is enforceable only by the board members. So if there's a member of the public that's unhappy with what happened and the board member that wasn't present, that didn't get 2 days notice, had no problem with it, well, that's too bad. Because that's a protection for board members to make sure that they are able to come to meetings that are called of the Board of Education.
So Chris,
Yeah.
2-day notice for board members, but notice to the community, news media, anyone else needs to be within 24 hours.
24 hours.
Special meetings.
Yep, exactly. Emergency meetings. Emergency meetings are a type of special meeting and is an exception to that 24-hour notice requirement of the Open Meetings Act. With an emergency meeting, the only notice you need to give to the media is as much notice as you're able to before you have the meeting. An emergency meeting is when something has happened that is so drastic that you need to act now. You can't wait 24 hours. The example that we give is perhaps there's been a catastrophe in the community and you need to get together right now. There's been a hurricane or a tornado that came through, a flood, something has happened that the board can't wait 24 hours. You need to get together right now. That emergency notice, all they look at is making sure there's been as much notice as practical to the media and anyone else who's asked for notice before you have that meeting. And as far as what constitutes an emergency, the cases that have looked at it, leave it to the discretion of the board to determine out whether there's been an emergency. An emergency doesn't mean you waited too long and all of a sudden, oh geez, we need to act on certain contract by a certain date and we were procrastinating and we weren't paying attention and all of a sudden it's the 11th hour. That's not necessarily an emergency. Rather, it's usually something that's outside of your control that a court's going to find would constitute an emergency.
So the majority of the time, the superintendent is the person that really calls an emergency meeting, correct? The majority of the time?
So with a special meeting, it still would be the treasurer or the board president or 2 board members. Now, Mr. Jolly may say to Dr. Rock, we got to get a meeting of the board together. And then Dr. Rock would provide notice to the media and do that. He would actually call the meeting based upon Mr. Jolly's request of him. But if Dr. Rock said, I'm not doing it, then Mr. Jolly would have to go to Mr. Roberts. If Mr. Roberts says, I'm not doing it, he has to find 2 board members. 2 board members said, I'm not doing it. Mr. Jolly cannot give notice to the media and call a public meeting. The final major section of what I want to talk about is executive session. And this is an area that, I go to a lot of board meetings and I see a lot of times where my clients get it right. And unfortunately, these times where perhaps they get it wrong. And so I want to spend a few minutes talking about how to properly go into executive session, why you can go into executive session, what you can do while you're in executive session, and the confidentiality aspects of executive session. So executive session, and you all are familiar with this, is when you convene out of public session into private in order to discuss something privately outside the view of the public as a public body. So you all go in the back room and everyone else stays out here and they're not privy to whatever you're talking about. That's an executive session. Because of the presumption of openness, so the public can see what you're doing, the statute sets forth very specific exceptions that allow you to go into executive session. And those are the only reasons you can go into executive session. In order to go into executive session, there must be a roll call vote that's passed by a majority of the quorum for purposes of going into that executive session. There must be a record, and you'll hear Dr. Rock cite what the reason is, make sure it's reflected in the minutes, because the minutes must reflect specifically why it was you went into executive session. That must be reflected in the motion that was made to go into executive session, and then take the roll call vote to make sure that you had a sufficient number of people voting in favor of going into that executive session. There are 7 permissible reasons for why a Board of Education can enter into executive session. Now, there's more reasons than that set forth in the statute, but they apply to like health districts and other types of public bodies that aren't you. So I'm only going to focus on the 7 that do apply to you. The first is the one that probably is the one you hit upon most of the time. It's to consider the appointment, employment, dismissal, discipline, promotion, demotion, or compensation of a public employee or official, or the investigation of charges or complaints against a public employee, official, licensee, or regulated individual, unless a public employee, official, licensee, or regulated individual requests a public hearing. So let's sort of break that down. The appointment employment, dismissal, discipline, promotion, demotion, or compensation of a public employee or investigation of charges. Nowhere in there does it say personnel. So going to executive session for personnel is not one of the reasons under the Open Meetings Act. And I say that specifically because there are many districts that feel these are all personnel items, so we're going to executive session for personnel. There's been court cases that have held that personnel is not a proper basis for going to executive session. The law wants you to be more specific than that. The law also doesn't want you to read that entire thing unless you literally are talking about all of those things, which, boy, what's the employment action doing with all those things at the same time? So if you're talking about hiring a new employee, then it's going to be about the employment of a public employee. Or maybe perhaps the employment, you don't know how much you're going to pay them, the employment and the compensation of a public employee. If you're talking about discipline or perhaps even firing somebody, then it'd be for the discipline or dismissal of a public employee. The law wants you to be as specific as you can when you go into that executive session so that someone who's sitting out here has a general idea of what you're going in there to talk about. Importantly, you don't have to say the name of the person. In fact, you probably should not say the name of the person for privacy purposes as far as who you're going to talk about while you're in executive session. Now, because it talks about in the statute again about a public employee or official, you're not able to go into executive session to talk generally about your employees. So going to executive session to talk about, we're going to do a reduction in force. We have a budget crunch. We've got to cut costs. We've got to go into executive session. We're going to talk with the board about 18 different employees I'm thinking about recommending for a reduction in force. There's been a case on this, and the court said that's not a proper reason for going to executive session because you're not talking about a public employee, you're talking about 18 public employees. And you're talking about the finances of the district, not employment, appointment, dismissal, et cetera. And so you have to be very careful in going to executive session to talk about an employee or a public official, not a group of employees. The only exception to that, of course, is if you're talking about collective bargaining, if you're talking about your union, for example, and about what authorization your board team has to negotiate with the union. There's a separate exception for that, but under this one, it has to be about a specific employee. A second basis for going to executive session is to consider the purchase of property for public purposes or the sale of property at competitive bidding, but only if premature disclosure of information is going to give an unfair competitive advantage to somebody or if whose interest is adverse to the board. So if you're generally talking about, a few years from now, we ought to think about buying some land so we can have a new site for the high school, as an example. That's not an executive session topic right there. You're just generally talking about potentially purchasing property at some point in the future. But if you've got your eye on a specific piece of property and you've got to talk to let your real estate agent know or whoever you're working with, this is as much as we're willing to pay for that property. You say that out here, and I'm the person selling the property, well, I just know what your bottom line is and what you're going to pay for it. You can go into executive session and talk about how much are you willing to pay, negotiation strategy, are you willing to swap a piece of property with the other party, whatever the case might be. That kind of thing is okay and permissible to talk about in executive session because it could give an unfair competitive advantage. Similarly, if you're looking to sell property, and you've already gone through the public auction process and no one purchased the property and now you're working with a realtor to try to sell your property privately, it's permissible to, again, talk about an executive session. We want to sell it for at least this much money. Don't go below this amount. Try to get as much as you can. Again, if I'm out here in the public and I want to buy that property and hear what your bottom line is, it's an advantage that the Open Meetings Act didn't contemplate trying to hurt districts that way. So that's a valid basis for going to executive session. A third basis, conference with an attorney for the public body concerning disputes involving that public body that are the subject of pending or imminent court action. So simply meeting with your attorney, talk about things, chit chat with the attorney, not a valid basis for going to executive session. It has to be about something which is the subject of pending or imminent court action. Either you're about to be sued, you're in the middle of a lawsuit, those are valid reasons because then you're there to get legal advice. As the attorney-client privilege is protected under both state and federal law. It's one of the most important privileges that exist out there. And in order for an attorney to advise you properly on that pending litigation, you need to be able to meet an executive session. But the legislature is not deemed it sufficiently important to extend that to other situations where you want perhaps legal advice from your attorney, but it doesn't involve pending or threatened litigation. Now, there will be other times. Again, if you're looking to potentially have a discipline or firing of an employee and you want legal advice, well, you already can go into executive session, talk about the dismissal or discipline of a public employee. You can just invite the attorney in to talk to you about that. But you're not there for the conference with an attorney about pending litigation. You're there for the discipline or dismissal of a public employee exception. As mentioned a minute ago, number 4, preparing for, conducting, or reviewing negotiations or bargaining sessions with public employees concerning their compensation or other terms and conditions of employment. You have collective bargaining coming up with one of your unions, and you want to work with your bargaining team to put together the initial proposal and provide input on what things you want to see or what you're willing to provide as far as a raise, what concessions you want to receive. That's all completely appropriate to talk about in executive session. Number 5, matters required to be kept confidential by federal law, regulations, or state statute. There are some things that you're required by state or federal law to keep confidential. For example, if you want to talk about a specific student, something going on with that student, while there are certain aspects of students that are public, directory information, a lot of what might come to your level as a board, unless it's a presentation about something wonderful that one of your scholars has done, probably it's going to be something that ends up in executive session because the Family Education Rights and Privacy Act requires to be kept confidential. If you're perhaps talking about an employee's health condition, that might be something that puts you into executive session because of that privacy aspect. So there's various exceptions that fall underneath that, but the important part is that it's required by state or federal law to be kept confidential. Not we'd like it to be kept confidential. We don't really want people to know. It's got to be a requirement of the law that it be confidential to fall within that exception. Number 6, details relative to security arrangements and emergency response protocols for a public body or public office. If disclosure of those matters could be expected to jeopardize the security of the public body or public office. So simply put, if you have active shooter drill information, I've got clients in the state where they actually have authorized teachers to carry guns in school, and there's exceptions for that. If you have protocols for what to do in the event of a bomb threat, things of that nature are all appropriate to be talked about in executive session that could jeopardize the safety of the district to have it discussed in open session. And then finally, number 7, and this is one I know you've used a couple of times, to consider confidential information related to negotiations within the political subdivision regarding a request for economic development assistance. So basically, if you've got a tax increment financing, or community reinvestment area agreement, one of these tax abatements that have been proposed that one of the public entities you interact with wants you to approve, and there's aspects of that that could relate to an economic development project that would put someone at risk or have the negotiations if it became public, could be adverse to the public body's interest. That's something you can talk about in executive session. So if you've got an entity that wants you to approve an abatement of 100% for 30 years and you want to talk about what concessions can we get, and there's details about the project you want to know about that have not been made public by that other municipal entity, that's something you can talk about in executive session. But to get there, it's a little bit different. With most of the time to go into executive session, all you need is a majority of the quorum to go into executive session. But for this specific exception, it must be unanimous quorum of the public body determines by a roll call vote that the executive session is necessary to protect the interests of the applicant or possible investment or expenditure of public funds. So there has to be unanimous quorum vote. All 5 board members voting yes to go into executive session, talk about that. If you don't have that, then you cannot go into executive session for that basis. As far as going to executive session, we talked about this a moment ago. The motion to go into executive session must be specific. These exceptions are narrowly construed. Again, as I said at the very start of the presentation, the courts have interpreted this to be in favor of openness. And if there's any doubt, the court's going to construe it in favor of openness, not in favor of secrecy. Once you're in executive session, what executive session allows you to do is to discuss and deliberate over the matter to be talked about. So again, if you're talking about hiring that teacher or disciplining that employee, you can talk about that. But you can't vote in executive session. As you know, votes are not taken in executive session. Straw votes should not be taken. Straw vote being, well, I would vote yes and I would vote no. And who here would vote yes and who here would vote no? That is discouraged and not something you can do in executive session. For people to share their thoughts, I think this person needs to be disciplined because what they did violated our rules. Or I think this person is an excellent candidate to hire for the position. You're expressing your opinion about that. That's part of deliberation. That's certainly acceptable and permitted to be done when you're properly in executive session. Importantly, when you go into executive session, you can only talk about the basis for why you went into executive session. I know you do a good job of that. I've been with you in executive session before, but I've been with many clients who people just start meandering and start talking about different things. And before you know, we were talking about discipline of someone, and then we're talking about board policy, and then we're talking about something that's happening next week that has nothing to do with why you went into executive session. And those discussions are not lawful. And the danger of that is that you have an unlawful discussion in executive session, and you later on take action on that, and it's found out you had an unlawful discussion, a member of the public could file a court action to invalidate your board action that grew out of the illegal executive session. That same remedy applies if you're having an unlawful meeting. So if there's an unlawful board meeting, you didn't have proper notice given, or board members got together secretly to talk about something, and later on you took action as a public body at a public session, that public action could be invalidated in court because it grew out of an unlawful meeting, whether it's the unlawful executive session or the unlawful meeting of the Board of Education. Final thing to talk about with executive sessions is confidentiality. Laws make clear that there's no express legal basis for confidentiality for executive sessions. A lot of times you'll hear boards say executive session is confidential. A lot of times that's because of your board policy. Your board policy says it's confidential, but the law doesn't say there's executive session is confidential. Now, there may be confidential items discussed in executive session. We talked a moment ago about student information and medical information, things like that can be confidential. Maybe other items that the board deems to be confidential by policy. And therefore you're required to keep it confidential. But there's no express privilege. I get asked this all the time. If you're subpoenaed to go to court and testify about something that happened in an executive session, can we say, I'm sorry, executive session privilege, we're not going to talk about it? No, that's not one of the privileges that exists for purposes of trial testimony. You'll need to testify upon that if called upon. But that doesn't mean, again, that as board members, you don't owe a duty of confidentiality because that's in your board policy. And one of the things that applies to you under your board member ethics provision in your board policy. And failure to observe that can be considered a violation of Revised Code 102.03 as a violation of your ethical duty as a board member. Finally, and I touched upon this a moment ago, violations of the Open Meetings Act if you have an illegal meeting, whether it's an illegal executive session, where you talk about things at executive session that weren't part of the reason why you went in, or you go in for an improper purpose to executive session, or if the meeting was not properly noticed. All these different technical things I've been talking about that are violated, and the board then takes action based upon them, that action can be invalidated in court. In addition to that, even if it's something that results in a board action being invalidated, a person who's aware of there being a violation of the Open Meetings Act can file a lawsuit and try to get statutory damages and an injunction against the board. There is a gentleman who's going around the state, perhaps you've heard of him, Brian Ames, who sued a lot of different school districts. He's got his own little cottage industry, nitpicking at board policies, nitpicking at how your minutes are put together, doing all those kinds of things, not just for boards. He's doing it to township trustees, he's doing it to cities, doing all kinds of public entities, because he's trying to enforce what he thinks is his vision of the Open Meetings Act. But that is something that he's permitted to do under Ohio law. And so it's certainly good to have sessions like this tonight. It's a refresher for you on what you can and cannot do. Any other questions of me this evening?
I have one, and it's probably for clarity. Any information, I'm going to say paper or whatever, is given to us in executive session should not be removed, should not be taken home. Should not be able to take that information home, correct?
Most boards have that as a rule, and the reason being of the confidentiality purposes, because that confidentiality is held by the Board of Education. The individual member takes that information with them. It becomes very difficult to still keep that confidential. And so I think most boards, yours and many that I work with as well, have it as a practice that if I hand out something in that executive session as an update to you on some legal case that I'm working on for you, I'll collect those at the end because that's an attorney-client privilege and it's confidential. I think you all want to make sure that stays confidential.
So what if we wanted that information emailed to us? Would that still be kind of up to the board or the attorney to say, yeah, I'd rather not send that via email?
My practice has been is I typically work through the board president on things of that nature. I think your policy designates the board president as the person that I would typically deal with when they're requesting information from the attorney. Let's say it wasn't an attorney-client privilege document. Let's say it was some other document you got in executive session and you wanted a copy of that. That gets back to the board and the board's designation of whether or not materials received in an executive session should be kept confidential or not. Much of what you're going to get in executive session, if it's not attorney-client privilege and it's not otherwise protected as being confidential, like, a student education record or employee's medical record, it's probably already a public record. So if you were given, for example, an employee's evaluation in executive session, that's a public record anyways. So it's not really confidential because it's already a public record.
Okay. What about a contract of some sort?
If the contract is one the board's already approved, again, it's a public record.
What if, no, let's just say it's something we're discussing to possibly be approved, but a contract has already been drafted. Could that, in essence, be shared with the board electronically?
It certainly could be shared with the board electronically. I'm not sure, there's not many circumstances where a contract, unless it's an employment contract, would find its way into an executive session because it wouldn't meet. Maybe a real estate contract to purchase property could, maybe an employment contract where you're going to talk about the compensation of the employee, that could find its way into executive session. Most contracts aren't going to find their way into executive session, but it's very common. The superintendent might send out an update to the board and attach several documents to that update. That update to the board, except for anything confidential within it, like, if you're talking about, Chris is undergoing surgery for whatever, you redact that as not being public, but that email is probably public record. The attachment to that email, probably public record. So yeah, that's really good.
And once it's board approved, it's going to become public record anyway.
Absolutely.
Thank you.
You're welcome. Any other
Chris,
questions?
Final question. This is probably minor. But you were talking about the individuals filing lawsuits and the like. How nitpicky have they been? Like, for example, let's say on our agenda, if we did item 3 before item 2, is that something that will fall into that situation, or?
No, and and it's a good question, Mr. Roberts, because I get the question about agendas frequently. Is it on the agenda properly? How's this agenda item read? We don't want to make sure you don't violate what the agenda rules are. Notice the word agenda probably isn't in this outline at all, because agendas aren't talked about under the Open Meetings Act. Agendas are set by your board policy, and typically because of the requirement of following Robert's Rules of Order. And Robert's Rules of Order will have items in there about how agendas are to be considered. So to the extent there's a violation of the agenda rules, really is a violation of your board policy. And the importance of that gets to be whether the board waives it or not. If the board waives that aspect of its policy for purposes of the agenda, you decide to take, if there was a motion right now, I move to amend the agenda to take item 3.1 ahead of item 2.2. That could happen. It's just, that's a lot of times why you do it up at 1.3 to make sure that everyone's on the same page at the start.
All right. Well, thank you very much, Chris. I just want to thank you. Oh, do you have another question right
Yeah,
there?
I got a question from Chris. When you come out of executive session, and say we filming like most districts film, should that be caught or captured on that video or?
And that's a great question, Mr. Freeman. That came up a couple of weeks ago. I was at a seminar, and the question came up of, how do we get out of executive session? Like, if we can't move and vote in executive session, do we move when we're out of executive session? And there actually was, I think we have a book on Robert's Rules of Order that talks about this. And basically says, when the executive session is over, someone just says, okay, I think we're done. You can walk out of your room. You come back in here, and then someone would say, okay, call the meeting back to order at, it's now 7:28. Like we've come out of executive session, but you don't need to have a vote to come out of executive session. You just want to simply reflect that we're now back in regular session and have the treasurer note that for purposes of the minutes.
Thank you so much, Chris.
And then you would just move the vote to close the meeting if that's the last thing you check.
Exactly, or take action if you're taking public action after the executive session.
Good. All right. Well, once again, I'd like to thank you very much for coming out and giving this briefing to keep us on the straight and narrow.
Absolutely,
So,
my pleasure.
Thank you very much.
Thank you, everyone. Have a good evening.
All right. Appreciate it. Thank you. All right. So at this point, I would like to slightly alter the agenda to bring up the members of our Tiger Cafe to address the board.
I'm sorry, so we're skipping. Is that what you said?
Just let the kids go.
Sorry, one of the students just had to leave. She had to get home. So sorry about that.
Right. Sorry.
But that was Janiyah that left. She's one of my seniors. And then this is Nia.
Hi.
Hey, Nia.
Any questions that you guys have for us for for the cafe at all.
So if you could just give an overview of the experience. I know you were there the first day it opened and how the experience evolved from the first day to the last day. And what are some um, things you would like to leave with the juniors coming up for next year? Some jewels that you would like to leave. So just a brief overview of your experience, like because basically you opened up a restaurant. Y'all opened up a restaurant. High school students with chef opened a restaurant, and the process of how it evolved to the end. All right, and just act like,
Just tell your
just
experience.
talk,
Like
and
you're talking
be
to one of your
comfortable.
friends. Tell one of your friends how the experience
Just
was.
talk. Just remember the people.
I dang. Oh,
You
hold
want
on,
me to
okay.
wait?
Yeah, a little bit.
There you go.
Overall, I think the experience was really nice. It was really cool to, learn how to work in a fast setting under a lot of pressure, just a little bit. But I feel like it helps us for the future and learn how to do this on our own when we do leave the school. Overall, from the beginning to the end, I feel like we improved a lot with our communication and how to work together. But program overall, can I say some things?
Sure.
Whatever you like.
Okay. I feel like for next year for seniors overall, how the class works, it kind of takes up most of our schedule. So now, as seniors now, we don't get a lunch because of how much the class takes up and the timing that we got to get from our school to the school that we go to now.
She's from Cleveland Heights.
Oh,
yeah,
okay.
sorry.
Cleveland Heights.
I understand.
So that's one thing that really was a big issue for us is that we don't really get to eat because by the time we get to school, we got to go in the kitchen and get ready for the restaurant. Another thing, I wrote this all down in my notes.
You're doing fine.
What did I say? Another thing I would say is as far as the teachers there, I would say that they not to be rude, that they don't really fully respect us. I feel like they appreciate what we do for them, which is nice, but like they would still come in after we're already closed to want us to keep giving them food, but we leave at 3 p.m. and we close at 2, and that's already not enough time to clean up.
So there's like teachers in a building. Got
Yeah.
it.
And I just feel like if they know what time we close and what time we open, so I feel like y'all should be considerate to come in when we're already open and to leave when we're closed instead of pushing our time back. So now the kitchen's not fully clean because we don't get enough time to clean up because y'all want to still choose to order.
Got it.
Okay.
Great feedback.
Thank you.
I don't really know what else to say.
So let me ask this. Did this spark you to want to start your own restaurant? Until you decided against that?
It's not really bad. It didn't spark my interest for me personally because I already work in a restaurant kind of place.
You can say where you
I
work.
work at Pizza Bogo. So
Okay.
I deal with customers on a daily. I know how it all works. I'm good with customer service. So doing this plus work, it's like it was too much for me. So it didn't really make me want to do this in the future, but it might change. It might be good for people next year. Things gonna evolve differently. So, but for me personally, no, I don't think it was for me.
So
Can I ask a question?
Go ahead, Ms. Mary.
Does it teach you guys though how to work as a team on
Yes,
a project?
definitely. I do definitely think that.
any other board members got a question?
I
got
do
one
have a
last
question for you. So the experience in working with chef and making these different meals, did that give you the incentive, like when you're on your own, like you said, another 4 or 5 years and you're cooking, did that spark your brain and like, oh, I can make this now?
Yeah, I like that we did a lot of food that wasn't just our culture. I like that we did like Asian and Chinese. I like that. So, it kind of taught us a little bit how to cook outside of what we already know.
Good job.
Microwave ramen.
Nothing's wrong with that.
Because we don't have a microwave. We don't have a microwave. We don't have a microwave on that reason.
What was your best experience in the kitchen? I mean, not in the kitchen, in the restaurant.
Want to talk about your week?
My week wasn't my favorite, which is crazy.
It's a lot of work, wasn't it?
A lot of special requests. That's just really the main part. My favorite. I'm trying to think. Sorry.
Competition.
Ooh.
Yeah.
Yeah.
Yeah, let's hear about that.
Okay.
Yeah.
Well, the whole prepping and practicing for competition was fun for me. We was in the kitchen every day. I felt like I got the menu down, even though I didn't make it to states, but it's okay. I feel like, what was the question?
Talking about competition. David threw out to talk about competition.
What they want to know. What do you
Just
guys
how-
want to know?
Just tell us
How
a
was
little
the
over
experience?
Just an
How was the
overview
experience
of
of
the
being on
competition.
competition?
It's really scary, honestly, because to be around other teachers and chefs that we never really seen before and to be judged on things that, not that chef doesn't judge us on those things, but to be judged by other people is kind of scary because it's like you feel like you're doing something wrong every little thing. But overall, it was a fun thing to do. You get your feet out there, try different things. I like the experience, and I wish I did this last year.
All right, I know.
She did do it last year.
I did product development.
She did
though.
product development last year. She started out with the Green Dream. Green Dream.
I made it to states.
No, we called it Green Romance.
Yeah,
We called it Green
What
Romance.
is Green Dream, if I may?
So we started out with Green Romance, correct?
Yeah, they said it was
So-
a.
And then in the competition,
name.
one of the judges said it sounded too much like a perfume.
Yeah.
So that's where they changed it to Green Dream. But tell them about it.
What do you want to know?
She wants to
What
know
is
What it is.
What is- give us the
What is it?
I've never heard
It
of
was a smoothie me and another
tasted it?
person that
Oh,
was in our
good.
class
Oh, it
made.
was a smoothie.
Yeah.
Yes.
Gotcha. Okay. Awesome.
So last year's was Green Dream. This year's was Pink Sunrise,
And
and
Beat in the
then
morning.
Meet the Beat. Beat the
Beat-
morning.
Thank
Beat the
you.
morning.
Mhm.
So, Chef, can you just share the trip to Seattle and just give everybody an overview of that?
So one of the biggest things is that we are I don't know if we're the first school, but this is since we've started at CCLA, we have gotten top gold back to back both years as juniors and seniors, with Nia starting the trend as a junior last year, and then somebody taking over this year for the gold medals because she wanted to compete in culinary. And the biggest thing is I want the students to see what happens at a national level, to see other kids come together over bigger competitions. So in Seattle, they'll do the culinary arts and baking and pastry, and that's where you're going to see kids like just from high schools that are around us that are just sleep and just cook all day long, and that's what they're going to be thinking about in their actual trip. And with Seattle, the students get to see that atmosphere of other students doing the same thing that they did to get to where they're going, and to see the networking that they can do with other students, to be like, oh, hey, you're from where? Where is Seattle? And when they talk about Seattle in class, they're like, are we going down or up? It's just like, it's up, not down, guys. It's Seattle. Where's it close to? It's close to Alaska. And the biggest thing is a lot of our students don't get out of this area, if you think about it. And we want to show them as being a part of culinary, being a part of anything, that we want to be able to give them the opportunity to see outside these borders of Warrensville. And the biggest thing is, their new thing is when we go to Columbus, they want BW3. Like, we're going to get chicken wings again, but it's something that we do every year when we go for a competition. It's their first day is always like they want to get BW3, just because it's remembrance of home and what?
It's a tradition.
It's a tradition. Yeah. And that's something too, is just making a tradition with the students and making something that they want to do. It's not, I don't force them to do this. Is that correct?
Correct.
Okay. But I do. No. No, but we did have a little prep talk beforehand. And the biggest thing about it is I want the students to come into class, and I want them to do it. I don't want them just to be here. And that's one of the biggest things we try to strive for the culinary classroom, is because I wanted them, the biggest thing too is that's why I wanted the chef of the week, because Nia learned the hard way for chef of the week. What did you learn that week?
What are you talking about?
What did you learn the week of your week as chef of the week?
My week is fine.
What was your food that week?
I had steak.
Oh, that was last week.
Yeah. Oh, you missed it.
I know
You
I
did.
got it.
No, he
on
got it.
Friday.
I
got
didn't
it
see
on Thursday.
you. I don't remember you being
I was
there.
there Thursday.
Did you get a steak?
It was good.
You had some?
You did a great
Thank
job.
you. Thank you. Thank you very much.
Well, I just want to personally thank Chef. You've done an outstanding job. Um, our program got to be considered one of the best programs in the area.
Mhm.
I would like to thank you and all the students in the program for all your hard work. You are a great group of young people. We hate to see y'all graduate and go. We hope that you come back.
Mhm.
And
Nia wants to. She already said she wants to come back next year.
yeah, and
I told her
mentor.
then she just can't pass grades. She can't pass at Cleveland Heights.
Mhm.
Do open enrollment
But-
in Warrensville.
Yeah, we would love for you to come back and mentor and be that because y'all pioneers. You know, this never existed. We all went to Warrensville, or our alumni, kids went to Warrensville. In this program, we are alumni from 1974 over there. Dennis Kaplan.
Yeah.
And this program did not exist. So the trailblazing things that you've done and you young people have done will be remembered forever. And I want you to understand, even though you are a Warrensville student,
Mhm.
because you went here for 2 years and
Mhm.
you're part of that Tiger tradition of starting something that no one else did. So I think on behalf of the board, I can actually, and not the board, but the whole alumni and city, say thank you to both of you.
So, and I also, I knew you were going to ask questions about our restaurant today. They did put the sign up. The sign is in today.
2 signs
then-
went up today. One in front, and then we put a big
Yeah, the one, yeah, because they finished the one yesterday while we were having a
Uh-huh.
restaurant yesterday.
Yeah.
Because we had that event yesterday for the all the other districts to come and see.
Yeah.
And they did finish the sign today. We did serve about 1,000 guests in the 15 weeks we were open.
Okay.
We did over 12,000 in sales in those 15 weeks.
Outstanding. Outstanding.
I was there. So
She has a question.
Go ahead.
Are the student volunteers for the program? How do you select those?
So the students are selected through the surveys that they do
Okay.
through the consortium. Some years I got to physically meet every single one of them.
Okay.
Other than that, it's per MOU, the memorandum of understanding throughout the consortium of how many picks per
Right.
student per
Every
school.
school gets a certain amount of seats.
I always wondered.
And if those
Yeah.
seats, if
I was like, why
another
they
school
pick me?
doesn't have enough seats, then they fill it from
Mhm.
other schools.
Mhm.
Warrensville's supposed to have the most seats, but we haven't filled all our seats, so other schools have taken
So,
them.
but we're on a waiting list. I have it maxed out at 25 for next year.
Okay.
And we're also going to have a gathering where we get to meet our students beforehand. We're hoping to do it before the end of the year to meet the students that are next year students. I've already had some Warrensville students come up to me in the hallway and be like, "Hey, I'm scheduled in your class next year. What's going on?"
Okay. All right.
So, and it's nice to see that. And there's nowhere else to go except for us in this program. So.
And he's catered, and we'll work on all the compensation and all those things.
I just wanna, is it Nia?
Nia Ray.
Nia.
Oh, you said
Yeah.
Ray this time?
Thank you.
So I just want to address you directly. I want to say thank you for being bold enough to come up here and talk to us.
Mhm.
What you said was honest and authentic. I like the fact that, you told us what some of the challenges were. I like the fact that you said you don't want to do this. It's not something you would want to do after high school. Not everybody that runs track wants to be a track star for the rest of their life. So, but it's the experience that you gain from it. And what I'm hearing is you got something out of it. And that's really all we can ask for. Chef, I want to thank you just for being the program and pioneering it and really being a cheerleader for everybody. It's been a game changer for us. It really has. And it's something that we can take our chest out about.
So the funnier thing is,
do the same thing.
we made cupcakes the first time for this graduating seniors this year. They were gone within 20 minutes. 200 cupcakes ransacked within 20 minutes.
I mean, they had Jamaican food. They had everything.
Yeah, no, that's one of the biggest things. That's one of the biggest things that gets the students going is the chef of the week, and that's one thing I will always have the students do because that's one thing. Like, hey, I want to see their culture. I want them to show their culture. I want them because what is wrong with me, Nia? What do I season with?
Salt and pepper.
And that's it.
It ain't enough.
And that's right here every time. So what did you guys do?
Add seasonings.
Exactly. So that's another thing too, is they made the Tiger Cafe seasoning. And that was one of the things I was like, I was just fed up with it. I was just like, guys, if you don't like me with salt and pepper, fine. Dry storage room, go make a seasoning mix. And we put it on everything.
Yeah, and he mentioned that we can possibly sell it.
So and that's one thing. So I would love to get a student to create barbecue sauce next year.
Okay.
And I'd love to get a student to create a non-salt seasoning.
Oh, that would be fantastic.
Exactly. See right there. Non-salt, non-sugar. How about that?
All right.
I'll take it all day long.
Yeah, non-salt, non-sugar. I know.
Could sell it, yeah.
Why'd you never tell us that?
Okay, we got some.
You never
And
told
he
us that
does
idea?
have a vendor, so.
Well, we could have did that for you this year.
All right. Well,
One
we
of us.
appreciate you.
Thank you both very, very much. Thank you, Nina, for coming.
Thank you.
All right,
Thank you.
Chef, take care, man.
Got the
All right.
whole city talking.
Enjoy.
All right.
Coming up to me from downtown talking.
Hey, are we allowed to escort ourselves out?
Yes, please.
Hey, you guys have a
All right, take care.
Yeah, I'll see you tomorrow.
Thank you very much. All right, next on the agenda, item 2.2, Dr. Rock with a financial update.
It's just a short update. First slide. I just wanted to give a quick update on the federal interest rates. At the beginning of the year, there was a lot of talk on decreasing the rates, and there was even more talk on decreasing the rates, more talk, and then now finally it's the Fed, because what they do is they'll ask the committee that's on the Feds, and they'll show how people are voting, and now it's down to the majority is looking at a possible reduction in rates later in the year, and read between the tea leaves on that, with what's happening in November and everything. But anyways, that's good news for us because right now the rates are pretty high and we're enjoying some great interest revenue for that right now. So right now, currently it's going to be, they're looking at a decrease late in the year. Next slide, please. The current rates right now, Star Ohio is 5.44. Our dollar bank money market fund is 5.63. Any investments that we get is 4.5 to 5.75, and that would be like CDs, governmental agencies, and bonds. Next slide. Okay, the interest rate environment. So right now, what we want to do is anything that we can invest, we want to try to lock in those rates before they start going down. But the rates decrease on the sale of investments that are anywhere from 18 to 2 years in duration, because of the Fed predicting that they're going to lower the rates. So we're sort of stuck, but any investable funds that we have, we're grabbing those rates and getting them as much as we can. The strategy is to lock in at better rates. And again, as interest revenue increases with higher rates, and it's always a cash flow analysis for us. In other words, can we invest these funds or do we need it for daily operations? And we've went over that model that I utilize for the district. It's been very successful for us. The next subject is the renewal of the emergency levy. I've mentioned this multiple times. The earliest that we could put it on the ballot would be November, this coming November, and the latest we could put it on would be next November. Superintendent Jolly and myself, we recommend to put it on for November, this November. Being that it's a presidential election, you'll have more turnout for the vote. So if we wanted to propose that, we have 2 resolutions that we have to do, and the deadlines are in August. So it would be nice if we can do the first resolution would be like May 22nd board meeting, if that's okay, and then June 26th would be like the next one, and we'd be within with some cushion, and that's the way I like to run it, because just in case something happens, we have some cushion in time. So I was just going to ask the board if it's okay, if I could go seek the resolution draft from council and bring that to the May 22nd meeting.
Which council? Council or the county? You said council.
Legal counsel.
County?
For Dan Latour from Pepple Wagner would draft up the resolution.
Oh, legal counsel.
Yeah. So, and then that resolution, then the board would review the resolution,
and approve the resolution. Then I take that resolution to the county and they certify it, and then we come back with paperwork, and that's the second resolution. Does that answer the question? I'm just trying to lay out all the steps. So is it okay for me to go get the draft resolution?
Anyone have any objection?
Okay. And then next board meeting, we also have the 5-year forecast, and the OASBO is coming to present that award to me too. Thank you. And that completes my section.
All right, thank you very much, Dr. Rock, and congratulations, and
Thank you.
we'll look forward to them coming next month. Next, we'll have an end-of-year update from Superintendent Jolly.
Yeah, so the board, I gave, pass this to me. Real brief, I just wanted to give everybody an update on what's going on at all schools. I don't know if I need to read it. I mean, all board members do have it. But for the public, every school has different events going on. To the end of the school year, highlighting at the high school graduation on June 2nd. Our Early Childhood Center has a prom tomorrow for kindergartners in pre-K from 5 to 7. They have their promotion at the high school on June 4th.
It's Friday.
It's Friday the 10th. I'm sorry, Friday the 10th.
The kindergarten prom.
I was doing a lineup at my house.
Yes.
They're gonna have they big wheels out.
I am so serious. She's got a red Camaro shade on a red carpet. Yes.
Okay, all right.
Yeah, this is at the Early Childhood Center.
I'm not the one that this is all mine.
Yeah. So it's gonna be an enjoyable event. Also at the middle school, we got Career Day on the 15th, and we have promotion on June 3rd, which will be at the high school. Our Early Childhood Center, we have our ballet presentation, which is on May 23rd. 5th grade talent show on May 5th. They have a lock-in for our Girl Scouts. They're gonna spend the night at the school on May 31st. And then we have 5th grade promotion on June 5th. So this is the overview. This will be posted on our website for everyone to have. But I just wanted to give the board an update on all the events so everyone knows when things are happening, and if you wanted to come and attend, it's available. That concludes my report.
And they're doing testing.
I'm sorry. I'll keep that time for the middle school whiz.
Your question, Mr. Freeman?
Yeah,
Early Childhood Center, I'm sorry.
the entire district's doing testing.
All districts are finished with testing, which they tested now. We start getting results next week.
Okay, thanks.
All right, thank you.
I have a question. Honestly, this is for the board more than anything. The different graduations that we've got going on, has anybody given any thought as to whether or not they're gonna be going? I'm just thinking board presence at the different graduations, even if it's just one with them. Something to think about. We got June 3rd. Oh, wait, so middle school and the early childhood center both have theirs on the same day?
I believe so at different times. I'll get the exact time
Yeah, it
tomorrow.
is different times.
Yeah.
June 3rd is for the middle school?
Yeah,
And
and
it's
June
ready to go.
And then June 4th.
3rd is kindergarten.
When is it?
I'll send you all the times. I'll email them to you tomorrow.
Okay, all right.
Any more questions, board?
Nope.
Okay, that we will move to item 3.1. Superintendent's recommendations and presentations of board action, certificated staff. Do we have a motion?
Mr. Chair, I move that we approve by consent agenda item 3.1, the resignation, which is the superintendent's recommendations and presentations for board action, certificated staff.
A second.
All right, it's been properly moved and seconded. Mr. Jolly?
These are resignations of teachers. That's all
Board,
I can say.
board, any questions? Dr. Rock, would you please call the roll?
Mrs. Moomin,
Yes.
Mr. Freeman,
Yes.
Ms. Mitchell,
Yes.
Mrs. Gator,
Yes.
Mr. Roberts.
Yes, motion passes 5-0. Next, we like to move into section 4. We have two items listed in section 4, and I would like to have them, normally we can do consent agendas. However, I'd like to have these both considered separately. So could I have a motion for item 4.1, please?
Mr. President, I'd like to move item number 4, Superintendent's Recommendation, Presentation for Personnel and Programs, item 4.1, volume 42, number 1.
I second.
All right, it's been properly moved and seconded. Mr. Jolly?
Yes, so the board policy, this is second reading. I know everyone received the board policies and I'm familiar with those. The second one, 4.2, I'd like to bring up Doug and Dennis to talk about the settlement agreement that we discussed with Affinity.
Do we need a vote on this one?
Let's do this one first.
It would take the vote on
you're gonna go
4.1
for the-
first.
Right. So, any questions?
No.
About the policy.
About the policy?
So we're not gonna go through them.
We can.
If you have any
we go
questions
through.
or concerns.
I thought we did.
Yeah, which one? There we go.
All right, well, I'll go with 3120.08. Now, which is revised employment for personnel of co-curricular activities. So there, I want to find this sheet. What I'm curious about is there's a cost that's associated with this.
Yeah, the district will have to incur those costs to get those people certified.
Okay. And then when this policy was drafted, I'm guessing that SWIFT was there, Brock was there, so all of the personnel.
Right, so it went to SWIFT. The cost, we don't know. A lot of times they pass these laws without having costs. We will come back with the cost of that.
Okay. All right. You know what, Mr. Jolly, I'll reach out to you. I don't have to hold everyone else up if they didn't have questions. I have specific questions.
Okay,
I'll
I
reach
can
out
call
to
you
you
tomorrow.
directly, but I will also just say this to the board. According to Neola, there's a couple of policies that have some language in there about artificial intelligence. So you might want to take a good look at 7540-3 and -4.
Okay.
So that might be something you guys want to look at. I'll reach out to you.
Okay.
Mr. John, I have one question, and because I wasn't at home, I didn't bring it with me, and that's the immunization. For those parents that do not allow their children to
Immunize.
how are we handling that?
So there's a religious exemption that people can get. It's a letter that we can, a parent can submit and be released from that.
Okay.
Very few people use it, but there is a religious exemption.
Okay. All right.
So if a parent brings that letter, then they are exempt.
Okay.
Can I go back to another, 7540 is not in this packet. That's in the next packet coming up, correct?
He referenced 42.1, which is what this is.
42.1 isn't in this packet either.
No. I'm saying volume 42, number 1.
Oh, volume
I'm sorry.
42.
I can reach out to him. He did say that those were supposed to be in there. I haven't had a chance to look at those, but there are policies coming down the pipe.
Okay.
Who stated that? Who stated that they supposed to be in there?
Joe from the old.
Oh.
Yeah, I don't remember seeing anything about AI in them.
So
I didn't see it either.
looked, but I did kind of run through it kind of quickly, and I didn't see anything either. But Mr. Doug, I do want one quick question, and I will reach out to you though. So the one that deals with intra-district open enrollment.
That's not really an issue for us because we only got one school per grade.
What's not an issue?
Inter-district open enrollment because we only have one school per grade.
It says the board shall permit any eligible elementary or middle school student in the district to apply, but it references middle school and the the elementary school or the middle school. So
Right.
maybe I'm just not understanding what we're saying in that.
So when it's intra-district, that means there's a big district that has multiple schools.
Right.
So just use Cleveland, for example, or when Warrensville had 3 elementary schools,
Okay.
and just say we had 3 middle schools, that's intra-district. When there's no options, because we don't have any options, we passed the policy vote. There's only 1 middle school. There's only 1 elementary school.
Okay.
So we don't really have anywhere to transfer to.
It becomes
Okay, so
not
that's what it's-
applicable.
okay. I didn't understand that.
Yeah, we don't
I was
have any.
talking about transfer.
Yeah, that's bigger districts that have options for people to go to.
Okay. All right.
But I'll sit tomorrow, we can talk and we'll go through
I
everything.
appreciate that. Thank you.
All right.
Any further questions? Board? All right, we'll go ahead with take a vote on this first reading.
This is the second.
Second reading, I apologize.
Oh, this was the second reading.
Yep.
But we can make it the first reading if y'all want to go back over it.
I thought I saw that it said first. reading.
Didn't y'all go over it?
It does.
What is that?
It states first.
Oh, okay.
I thought, so is it the first or no?
It's the
I thought y'all
second.
voted
It
on
says
it.
the second.
Yeah, I thought y'all voted on it
It's
before.
it's actually the third time it's been on. It's been
Okay.
on once.
We pulled it
Mr.
once.
Jolly wasn't here,
Yeah,
and
we
then we
pulled it,
read
so-
it last meeting
Okay.
when
so
Mr.
it
Jolly
was-
was there.
Okay, so this is actually the second.
Yeah, I'm sorry I
Okay.
missed that.
So do we need to correct that somehow?
Yeah, corrected in the motion.
So what reading is this, Dr. Rook, the second reading?
It'll be the
Second
second reading. So we have a motion.
Oh, I got it, okay. Mr. President, I'd like to rescind item number 4, the superintendent recommendation and presentation of personnel and programs, item 4.1.
I second.
All right, it's been properly moved and seconded. Is there any further discussion, board?
No.
All right, Dr. Rock, would you please call the roll?
Mr. Freeman,
Yes.
Miss Mitchell,
Yeah.
Mrs. Moomin,
Yes.
Mrs. Gator,
Yes.
Mr. Roberts.
Yes, motion passes 5-0. Next, we come to item 4.2, settlement agreement and mutual release.
Yeah, we got to vote
We
on
have to vote.
4.1.
Oh, I'm sorry.
So, Mr. Chair,
That was the,
yeah, we have to.
that was the
proceed.
change, okay.
Yeah,
Mr. Chair, I'd like to recommend that we approve item 4.1, policy volume 42, number 1, correcting the recommended action from the first reading to the second reading. And this falls under superintendent's recommendations and presentations for personnel and programs.
I'll second that.
Thank you very much. And now it's been properly moved and seconded. Dr. Rock, please call the roll.
Miss Mitchell,
Yes.
Mrs. Moomin,
Yes.
Mr. Freeman,
yes.
Mrs. Gator,
Yes.
Mr. Roberts.
Yes, motion passes 5-0. Next, item 4.2, settlement agreement and mutual release. Do I have a motion?
Mr. Chair, I move that we approve item 4.2, settlement agreement and mutual release.
Do I have a-
Second.
All right, it's been properly moved and seconded. Mr. Jolly.
Yes, I would like to bring up Doug and Mr. Kaplan to come up to discuss our settlement with, our proposed settlement with Infinity Construction. This settlement was a negotiation based upon the project being late and damages to the district based upon them being late. These two young gentlemen, Mr. Kaplan, who is Mr. Kaplan, who represents the state, who's a co-owner on the buildings with us, and Mr. Doug, who served as our representative. And I wanted them both to just share their insights on the settlement and their thoughts on the settlement and why they believe the settlement is worthy of the district, you guys' approval.
Sure. Yeah, so as Mr. Jolly mentioned, this is a settlement agreement. This is really for the issue that the project was not finished per the contract within the contract time. So the settlement agreement between the school, OFCC, and Infinity, it only addresses that issue. So the school district spent more money to get done sooner. There was hardships that were provided. We went through a mediation where we talked to all the different parties to come up with the settlement. And ultimately, the settlement was drafted up by the OFCC and the Attorney General. So, and it's been agreed to by Infinity. The settlement terms basically are it's $1 million, which is made up of the return of unused CMR contingency, and it'll also be a deduct change order. So this is money that's going to basically, it was contracted to Infinity that will come back to the district. This does not, we still have punch list items that we're working with. We'll still have an 11-month walkthrough. We still have some construction work with replacing the sidewalk on Northfield. All of the terms of the contract still need to be completed, and we're still meeting with Infinity to kind of wrap all those up.
And it also covers the responsibility of post-construction issues never goes away. They're still responsible for the contractor, still responsible for the construction. I've had projects, one of them was East Cleveland. We found something 15 years later with the masonry. According to the AG's office, defective work. We just got to go ahead and figure out how we prove it. And we did some investigations. So that will never change. Their responsibility to this project stays. If we find something out 2 years from now, like we found out at the PK5, we'll hold their feet to the fire and we'll make them fix it. And that doesn't work. We have legal and the AG's office to go after for that. So, but yeah, it's a good thing for Warrensville. I was always adamant that we need to get some money back from them. You've done it. I've talked about that. It's just, you always want more, but I think this is a good deal for the district. So, you know, you guys are into some over budget, so you paid some money over budget, that co-funded stuff. So this will help relieve that, which is a good thing here at the end of the day. So, yeah.
And you're from the state?
Yes, I work for the OFCC, and I'm an alumni. So for me, it's a little bit. For me, it's also a big deal. I wanted to come back and do this project because you go to school here, and you come back around, and it's cool to do this again. You know, and you meet people like Ray and Brad Sellers and all you folks, and it's just cool. And so you want to. I do it all my districts, but this one was special to make sure we got get you guys whole. So you know.
Anybody have any questions? So just a summation, it's a return of $1 million to the district. And I appreciate you guys and your support throughout the project. Dennis has been with us since the beginning. Appreciate your guidance and wisdom and pushing real hard to make sure that we were treated fairly. I cannot express how Dennis pushed to make sure we were treated fairly and we weren't taken advantage of, and to hold the construction company accountable. He was very adamant, very heated conversations, But I can say that he had the best interests of the district. And I appreciate Doug for guiding us in a lot of things we don't know. And we trusted his company and Doug to make sure. And as a team, I believe we were represented well in this project. And when it went off course a little, we were able to overcome all the obstacles. And as a result, we were able to get $1 million back. So I think that it's a testimony to the work of these guys. And Dennis been with us since we're 18, since we started. Since we started, so it's been 6 years and it's coming to an end. And Doug's been with us the same way. But every week, meeting, 2-3 times a week. It's been a long journey to get here. And we're here, and we still got a little ways to go. But I just wanted to publicly say thank you.
Thank you.
Thank you. With us, right?
Yeah.
You haven't completed.
Almost done.
Doug's like that.
Still here.
Yes, coming to the end though.
So a little process question for me. You guys are going to sign that agreement tonight?
Or
you want to sign it and let me know when I got to let legal know because we take this to the commission. The commission is coming up soon. So I just got to let them know that the document's coming or when it's
so we can sign it tonight.
Yeah,
the board president can sign it as soon as they approve.
As soon as
and
it's
we can
approved.
Great. And
hand you a copy of it.
I can scan it, get the legal tomorrow.
Okay.
All right, that's great.
Great.
Board, any additional questions?
Just want to thank these guys. They've been there, like Jolly said, day one. I mean, we didn't have some heated battles at that table. And I want to thank you, Dennis. I want to thank you,
We had
Doug.
some interesting conversations on topic.
Yeah, I mean, almost like me raising tables. So I want to thank you guys.
It seems like we're united in thanking you for your advocacy for our district. Thank you very much.
Our pleasure. Yeah.
All right. Dr. Rock, would you please call the roll?
Mrs. Moomin,
Yes.
Mr. Freeman,
Yes.
Ms. Mitchell,
Yes.
Mrs. Gator,
Yes.
Mr. Roberts.
Yes, motion passes 5-0.
Thank you very much.
Thank you very much.
Thank you.
All right, next item on the agenda, item number 5.
We're adjourned.
Are there any announcements, Mr. Jolly?
No announcements.
Dr. Rock, any announcements?
Ready? No announcements.
No, we've received nothing. All right, and brings us to item number 6. Do I have a motion to adjourn?
Can I ask a question?
Oh, yes, please.
I'm sorry. So we've got the retreat next week, and I know that we're going over the evaluations. Can you just explain, is there an expectation for Rock and Jolly to complete the evaluation before we get there, or are they going to walk us through the process?
No, actually, the process should be concluded. You know, we should be able to go through the complete process during the retreat. Following the retreat, our facilitator will send us out the information to review and approve and finalize shortly thereafter.
So are they doing informative with us? Is that what?
Yes, well, Mr. Jolly and Dr. Rock are scheduled to meet with the facilitator next week.
Tuesday, yeah.
Yeah, so they're scheduled to meet with the facilitator in advance of the retreat.
Okay.
They'll put their portion of the information together. Then we'll go over that with the facilitator during the retreat and take time for each individual evaluation. And should their expectation is that we should have a product ready to be reviewed and approved by us shortly after the completion of the retreat.
The formative.
Yeah, yes.
And then we will still need to come back and do the summative ourselves.
No.
This should
We should be able to have a complete product for us to review at the end of the retreat.
Well, there's two different sections to it. There's formative,
The-
which should have been done a couple of months ago,
Mhm.
and then the one at the end. So you're saying you can't do it all because the year's not over.
This
So
is
maybe I'm missing something.
Our expectation is to have the process completed, you know, for the most part, during the body of the retreat. And then following the retreat, the facilitator will send the information out to us for review, comment, adjustment, and the like. And then we'll be able to go forward and finalize it at that time. But that's what the retreat is for, is to take us through the process. So, maybe we should.
They're gonna do the formative and the summative during the retreat, is that?
Actually, I will say yes, because we're going to complete the process. We're going to use the retreat to go through the process.
But I don't think we can do that, Earl, because a portion of it is.
I understand.
Can I finish? Because a portion of it deals with the goals and stuff that they have to establish, and Jolly can't establish goals off of that until after the school year is over and we get the grades back and things like that. So that's what I'm asking.
So I want to add that if it's not complete, if you get a draft on the 18th, we will have the scores by the end of May. And then whatever the final, we have the final scores by June, by beginning of June.
Yeah.
So I'm just adding that to your conversation.
And also the facilitator has a proposal for the board to get us on a schedule that's more aligned right with the school year.
Right.
He has a calendar process that he wants to, we haven't seen it yet, but he's going to propose that to you and present that to you at the retreat.
Right.
That'll get us more on, covering it from the beginning of the school year. So, because obviously we're off alignment with the school year right now.
Right.
So that's why it's sort of like a catch up. And I see what your questions are. I agree with you, Mrs. Gator, but he's going to present something,
Right.
and it's not, and nothing's written in stone, but I mean, if you like what he's presenting, he's trying to get us on a calendar
Right.
that goes with the school calendar.
And yeah, his proposal was to have us complete this year at this time, and then down the road, set up a schedule going forward. But that actually is the intent, is to complete the evaluation process based upon the process that they take us through at this retreat. So, I mean, if there are, you know, any objections, of course, they can be brought up at that time, but I believe we should just let the retreat unfold and, you know,
But I
go
just
from
wanted
there.
to know what to expect. We really haven't heard anything, so I appreciate you giving us the
All right.
information.
Any other announcements, board? All right, is there a motion to adjourn?
Mr. President, I'd like to adjourn tonight's meeting.
I have a motion. Is there a second?
Second.
It's been properly moved and seconded. Dr. Rock, would you please call the roll?
Mr. Freeman,
Yes.
Ms. Mitchell, Mrs. Moomin,
Ms. Bowman?
Yes.
Mrs. Gator,
Yes.
Mr. Roberts.
Yes. Motion passes